Every major step toward undoing racial oppression in America has been met with the charge that it constitutes reverse discrimination against whites, an unfair preference for people of color. Consider America's first federal civil rights law. The Civil Rights Act of 1866 declared all persons born in the United States citizens. It also clothed all persons with the same rights as whites for purposes of suing or being sued, contracting, owning property, or serving as witnesses. Prior to this legislation, the Supreme Court, pursuant to the notorious Dred Scott decision, had ruled that blacks, whether free or enslaved, were not citizens of the United States. The federal government and many states, moreover, had openly barred blacks and other racial minorities from exercising even the most elementary civil rights. President Abraham Lincoln's successor, President Andrew Johnson, vetoed the Civil Rights Act, charging that it represented special legislation. He disliked the citizenship provision because it would immediately make citizens of native-born blacks, while European-born immigrants had to wait several years in order to qualify for citizenship via naturalization. According to Johnson, this proposed a discrimination against large numbers of intelligent, worthy, and patriotic foreigners and in favor of the Negro. Johnson similarly disliked the provision that authorized federal judicial enforcement of rights that, for some purposes, contracting, owning property, suing, and testifying, placed blacks on the same plane as whites. This part of the bill, Johnson complained, affords discriminatory protection to colored persons. According to Johnson, these arrangements established for the security of the colored race safeguards which go infinitely beyond any that the general government has ever provided for the white race. In fact, the distinction of race and color is by the bill made to operate in favor of the colored and against the white race. The Civil Rights Act and Johnson's veto, which was eventually overridden, highlight two important points. One has to do with overlooked complexities regarding what counts as race-sensitive, as opposed to race-blind, policy. Johnson characterized the Act of 1866 as illicitly race-sensitive insofar as it contained, in his view, a distinction of race made to operate in favor of the colored and against the white race. Was this charge racial demagoguery? Partly. The Act did simply stipulate that, with respect to the activities named, parties shall merely have the same rights as are enjoyed by white citizens. On the other hand, Johnson was correct in observing that this exertion of federal power was unprecedented and that the dominant purpose behind it was to elevate the legal status of African Americans. Many observers today consider the Act of 1866 to be race-blind, but textually, the Act is explicitly attentive to race, and its framers were moved primarily by a desire to help a particular sector of the populace, colored Americans. The Act of 1866 can thus be seen as a race-sensitive precursor of affirmative action. A second point accentuated by the Act of 1866 and Johnson's veto of it is the alacrity with which many have deployed the rhetoric of reverse discrimination in attacking reforms that diminish white privilege. Those who sought to abolish slavery, a Florida slaveholder fumed, were determined to give the nigger more privileges than the white man. With the abolition of slavery only a year old, President Johnson was already claiming that blacks and their allies were seeking racial favoritism. In 1874, disapproving of federal legislation prohibiting racial discrimination in the provision of public accommodations, the Chicago Tribune asked, in an editorial entitled, "The Nigger School?" Is it not time for the colored race to stop playing baby? In 1883, in the course of invalidating parts of that same legislation, the Supreme Court accused blacks of seeking preferential treatment by demanding the end of caste-like exclusions. Impatiently lecturing the black plaintiffs in the civil rights cases, the court declared that, when a man has emerged from slavery, there must be some stage in the progress of his elevation when he takes the rank of a mere citizen and ceases to be the special favorite of the laws.